Good morning. We have several motions that are set on the docket for today, so we will run through the docket. If you'll call the first case, please.
2022-CR225, Paul Shane Garrett.
Mr. Potter's online, I think.
Good morning, Your Honor. My name is Catalina Goodwin. I also represent Paul Shane Garrett from Knoxville.
All right. Mr. Potter, can you hear us okay? You need to unmute your device. It's that little thing that has an icon that looks like that's got a slash through it, and there you go. I know you're a man of your advanced years, probably has no expertise in electronic devices. So.
My kids are not here to help, so thank you, Grace. I think that I'm going to defer to Ms. Goodwin, but I think there was a meeting yesterday between defense counsel and the district attorney's office, Mr. Crouch's office. I think the plan is to move, set it on the review date, if we could, for August the 19th. Is that right, Ms. Goodwin?
Yes, that's correct. And Your Honor, we did have a good meeting with the district attorney yesterday. We're hopeful that we will continue to have productive discussions with them. As Your Honor knows, we have several motions pending before the court, but at this time, we want to focus on continuing those discussions and coming back on August 19th with hopefully something to tell you all. And I will go ahead and preview for you. Right now, that case is on the docket for September. Mr. Johnson and I are going to be in trial in a federal case in Memphis for the entire month of September and have a conflict with that date anyway.
Well, under the rule that the new procedure that I'm following, I am not going to assign a trial date to this case until all of the pretrial motions have been heard. So we will assign you a trial date on that August 19th, and that will be the last day that we'll be able to settle this case by any sort of settlement agreement. Past August 19th, we'll set a trial date, and the defendant will either plead to the indictment, every count of the indictment, and go to sentencing, or the case will go to trial. Or the state can nolly it if they choose to. Those are the three options under this new rule that we're following. So it's designed to avoid using trial dates for cases that don't get tried. So we're trying to avoid that. So we'll set it for August 19th for any motions that you may have that need to be heard on that day. And obviously, hopefully, you'll be able to continue your negotiations and maybe come up with a resolution.
Yes, sir.
All
Thank
right.
you, Your Honor.
All right.
Thank you.
Thank you, Judge.
I have one other matter that that's not on the docket. This is in the matter of All-Star Bail Bonding Company and for the approval of a Shelley Ann Purcell as an authorized bail agent. If you'll come on up, please. I'm going to ask you to go to the podium. Is that microphone on? Okay. Good morning. If you'll raise your right hand, let's place you under oath. All right, thank you. You are Shelley Ann Purcell. You can stand right there. I'm not finished with you yet. So, Ms. Purcell, you have it's been indicated that All-Star Bail Bonding wants to add you as a bail agent for their company, and I'm required under our local rules to make sure that you're familiar with the rules and procedures. First and foremost, have you familiarized yourself with the state statutes regarding bail bonding and the responsibilities and duties of a bail agent?
Yes, Your Honor.
And have you also familiarized yourself with the local rules of the 23rd Judicial District regarding bail bonding and the responsibilities and duties of a bail agent?
Sure.
Do you swear under oath that you will perform those duties and comply with all of the requirements of both the state statutes and the local ordinances or local rules of procedure that the 23rd Judicial District has regarding bailing?
I do.
All right, then I will authorize you as a bail agent for All-Star Bonding. So I'm going to sign this order, and then you can get a copy of it. You or your employer can get a copy of it a little later. All right, thank you. Ms. McKinney, do you want this or do you want me to give it to you? All right, call the next case. Patricia Denise Kelly. Mr. Belmars cannot negotiate Zoom well enough to get onto a Zoom hearing. Did you send him the link again? All right, well, we'll pass it and come back to it. So. Right, and I'll pass your case to the second call. And those, that's what we had for today. Now, tomorrow we have a motion to suppress and Jesse Kinder. I need to check on that case for Friday as well, Wiley versus. All right. Was that with me or with someone? I have Chancery on Friday. Yeah. Okay. Well, I'm going to step off and see if you can round up Mr. Belmars, and if you and Mr. Brooks are able to continue talking about your case, then you can let me know what happens. Hold back. All right. Were you able to reach Mr. Bell-Myers? Bell-Myers, if you would like to have some lessons on how to join a Zoom link, we'll be glad to let one of the staff here. All right. Then let's deal with State versus Patricia Denise Kelly. That's, I believe, General Bryson's motion to allow the release of certain information. Is that correct?
Yes, Judge. This case was reset the last time in part because we were still endeavoring to get discovery.
Is this the one where the grandmother is charged with abusing a grandchild?
Yes.
All right.
And so during the course of this case, who has had custody of the child has changed. The mother has been in communication with me. She has met up with me in person to execute medical releases. We did not check the correct box for Vanderbilt to release these particular photographs. I think we checked every other box on them. And so Vanderbilt has let me know the court cannot order them to release these photos, but you can issue an order allowing them to release these photos. And it would be of assistance to me. The victim.
Let me ask this question. What about a judicial subpoena that would be a court order directing them to release that information? And you're telling me Vanderbilt says, nah, we're not going to comply with a judicial subpoena? Then I could cite the Vanderbilt Hospital, who is the director of the Vanderbilt Hospital, in the court on a show cause for contempt as to why they shouldn't be held in contempt for not complying with a court order.
You know, I have this order that's really easy to sign and already drafted.
All right. Mr. Bell-Myers, do you wish to be heard on that point? I just don't take it well when somebody like a Vanderbilt Hospital or anyone else says that they don't care what the court says about ordering them to do something, they're not going to do it. So,
Well,
you ever see the movie Lincoln, where Lincoln's character says, "I am the president of the United States. I am clothed with immense power."
Yes, Your Honor, and I have endeavored to have discussions with them about what HIPAA says or does not say, and I don't know, I guess my law degree isn't worth quite as much.
We'll try it in the nice way.
Okay, thank you,
If
Judge.
that doesn't work, we'll use the hammer or the sledgehammer or whatever it needs to be. I have signed your order allowing the release of the information, and we'll cross our fingers and hope really well that Vanderbilt will do what they're supposed to do. So,
Yes, Judge, thank you.
all right, next case is State of Tennessee versus Devin Pollard. This is a motion, I believe, that has been filed by, and first and foremost, I believe both of you have received a copy of the order that I have drafted and entered today on the Rule 412 motion. And I think that order is self-explanatory, but we're now dealing with the newest motion that you have filed, which is the motion for, two motions, one to continue the trial, but the other is to appoint an expert witness. So we'll hear you on the expert witness.
Thank you, Your Honor. Judge, this is a motion for appointment of an expert witness. Specifically, there is an individual whose skill set my client made me aware of. He did so the day before our last setting for trial, so I had to explain that unless he wanted the case to be continued, this was probably something that we would not be getting to in his case. As the trial was continued, as soon as it was, I began work on trying to locate this expert witness, who turned out to be one Dr. Laura Brody of Wiggins, Mississippi. Miss Brody is certified as an expert witness here in the state of Tennessee, testifies mostly, as I understand it, in Knoxville and their judicial district. She has been used as an expert by the 23rd Judicial District's Public Defender's Office, and that's how I was able to obtain her CV and speak to her. Specifically, Judge, Dr. Brody evaluates examinations and interrogations. So she is specifically trained in evaluating the manner in which children who are making accusations of sexual misconduct and or sexual crimes, such as this case, and determines whether or not those interviews were conducted in a way most conducive to the defendant's due process and other constitutional rights. Dr. Brody, more specifically, will actually accept the AOC's meager rates, which most people will not. The AOC only offers $150 an hour. We're asking for a total of 20 hours, not to exceed $3,000. To say that the process of doing this for an indigent defendant is opaque and difficult to navigate is to belittle the opacity and difficulty of this. We believe that the motion complies with 13(4)A in every aspect which we could find. The only issue that I am concerned about, Judge, is that we are required to seek out an expert, a comparable expert that would be in a 150-mile radius of Dixon County, Tennessee. I reached out to the Tennessee Board of Psychology. I also reached out to the Tennessee Bar Association. I was given precisely zero assistance in trying to find someone else of comparable skill. So I am reasonably certain, considering after talking to the local public defender's office and got an appointment to speak to one of the attorneys that she's dealt with in Knoxville, that her expertise is specific and limited enough that that already puts her in a very small category of available witnesses. And then you add to that that she is willing to accept the AOC's rates. And I do think that we have satisfied the requirements of the rule per the administrative office of the courts. Her CV is attached to the motion, Judge. I think you'll see that she has some pretty interesting, pretty interesting background. And I believe, Judge, that, my client was right. I think that there's a great deal in these interviews that should be evaluated by an expert. To give an example, there was one instance where the question was asked, when was she screaming? Well, nobody had ever said scream before. Not the person who was alleged to be the victim, not the witness who was being interviewed. I think there were quite a few things planted in questioning that warrant the evaluation by a professional. It is for that reason, Your Honor, that I'm asking for continuance. I'm also asking for continuance because we have issued some subpoenas for phone records, specifically the phone records. Again, Judge, just because I knew we had a little more time, but they haven't come through yet. Specifically the phone records of AW, which were not provided in discovery. And so we'd like to get a look at those as well. So I've got, Judge.
Let me ask this question. Let's assume that I authorize this expenditure for this expert witness, and let's assume that this expert witness reviews all of this information that comes in. What will be the purpose for which her testimony is offered? Because my concern is that you cannot bring an expert witness in to simply say, oh, I think somebody's lying, or I think they're telling the truth or not telling the truth. That's the ultimate issue for the jury. So what purpose would this particular witness serve if she is in fact authorized as an expert witness? Psychological expert, and there is a difference as well, because in most of these cases you're dealing with very young children who make an allegation, and then an expert witness is brought in who's expert in child psychology and can key in on certain cues and certain tells, so to speak, that a child is not being truthful or that something is not consistent. But in this case, the alleged victims were high school students, not minor children, not young children anyway.
It's my understanding that she will still approach the evaluation through that lens, but that isn't primarily the reason that I want this evaluation. The reason I want this evaluation, Judge, is because she is specifically trained in evaluating the questioner and the questioning, particularly looking for answers planted in questions leading questions, questions that tend to suggest an answer, whether that is in fact the answer that the child would give or would not give, without the leading, without the planting. And I know that that is, like I said, that is a very, very specific avenue, but that is what she is best at, and that is what I think that it would be, to answer your primary question, Your Honor, it would be to the veracity of the alleged victim's testimony, as you've already pointed out, if, you know, there were indicators that they were being, you know, somehow manipulated, led. But it would also be to evaluate the manner in which these children were interviewed and interrogated.
No, you claim I don't. I haven't.
If they're anything like my file, they're in
Now,
the overflow.
let me hear from Mr. Brooks.
Yes, sir.
I'm sorry.
I would ask the call to Detective Katrina Pulley.
All right.
Sent me.
He's aware of this hearing, isn't he?
Yes, sir, he
He's
is.
on bond, so he has the ability to be here or not be here.
Yes, sir, I understand. But what is being referenced is confidential attorney-client conversation. Unless there is a really, really, really good reason. I don't believe it's appropriate.
Attorney-client privilege only applies to conversations between her and the client, not conversations he has with other people.
Also leaves me in an impossible position, Your Honor, because I can make zero comment on that. I can't argue for, against, I can't say that it's true, not true. It literally makes me incompetent counsel.
I cannot rule on whether or not this is or is not privileged or admissible until I actually hear it. So your objection is overruled. We're going to allow them to play it. Now, whether or not that information can be used at trial is another matter.
It is not proved to be her.
All right. Then I overrule the motion, overrule your objection. We'll allow Mr. Brooks to put on his proof. Ms. Detective, if you'll come forward, please.
And again, to clarify, Your Honor, this is not evidence at trial. This is only for the limited purposes of this hearing.
All right.
Can you please state your name for the record?
Yes, Katrina Pulley,
And where are you employed?
Dixon Police Department.
And what is your position?
I'm a detective.
And have you been employed in that capacity since 2021?
Yes.
And what is your involvement in this case?
Lead investigator.
If I could pass this up to the detective. Detective Pulley, what did I just hand you?
CD.
Okay, and what is contained in that CD?
A jail call.
Between who?
Mr. Pollard and a female who is believed to be his mother.
Okay. How is that phone call obtained?
Through the jail system, phone call system.
Okay. And how do you know it's Mr. Pollard?
During my investigation, since Mr. Pollard has been incarcerated at the Dixon County Jail, I have listened to numerous phone calls that he has made, and the voice is the same.
And have you spoken to him over the phone as well?
I have. That was during the beginning of my investigation.
And what is the date of this phone call?
I believe it was 3/13 of 24.
Is that prior to him? I assume if it's a jail phone call, it's probably prior to him making bond.
Correct.
Okay. Your Honor, I'd ask to publish that.
overrule the objection. She has identified the fact that she is familiar with the defendant's voice and that she has listened to numerous phone calls. And it is a matter of record that the jail calls of an inmate are routinely recorded. And in fact, they say on the recording that they are being recorded. So for that reason, I think that Detective Cooley has sufficiently established her familiarity with the defendant's voice to allow this to be played. Mark it as an exhibit, please.
Attempt to play it to the.
This is a call from an inmate at a correctional facility. This call is also subject to being recorded or monitored except for privileged communications between attorney and client.
All right, shit. Hello? Hey, Mom. Hey, Dad. What you doing? Looking for all y'all's information, every ID possible, her social, your shit, my shit, because I keep all of our stuff together. Right. Your name on stuff, theirs, mine. This one, there's one. What? You got my birth certificate in my social? You got something like that? Yep. Yeah, I got all. Yeah. Good. Good. going on such a I'm gonna have to go through all this stuff. I took it under those picture frames so it wouldn't get lost. There it is. Man. Oh, not as
You said who birth certificate?
Maddie.
Maddie's.
Yeah.
GB has everything in the cut.
You should see this damn thing she got. I say everything. I had to ask her. I asked her not too long ago. I said, why the fuck you still got this over there? It's like the I think it was like one of our preschool things, like where they do your handprint and your feet print and shit.
Right.
All that shit. Bring coffee in there, man. I don't need this for nothing now, but she was saying that she had our marriage stuff. I was asking was there still green coffee in there because I ain't paying for another one. They want $21 for a sheet of paper. Fuck you.
Right.
Say I'm married. Get out of here. Ooh, this makes my soul so happy. Wouldn't they reschedule the trial date for it?
Detective Pulley, is this when they start discussing the style of the case?
Yes.
The first, I'm gonna have to come back in June, but like Kelly said, once I get out, we'll be able to.
This call will be terminated in 2 minutes.
She gonna delay it as long as possible.
All right.
So I'll just basically make an
Is
appearance
it the
in June.
beginning of June or the end of June?
It's the end of June, like the 25th, 26th, something like that, 27th, something.
Because I was already taking time off that week to go to Tennessee when we were going to New Orleans.
Right. Cool.
Okay, go ahead and take that whole week off. That way we can be there for court and then go on to New Orleans.
Yeah. I'm going to, because I want to go to New Orleans. I ain't got no geographical restrictions. I can go, I got the angle thing on, but I can go anywhere. We just cleared that up.
Yeah, we got some trips planned. We might be going to New Orleans twice this summer. We got some trips planned. We'll have some good time.
Yeah.
This call will be terminated in 1 minute.
We're talking about having I just said they're talking about doing a family reunion for our side too, a cousin gathering.
For mama's side?
Yeah. We got left as cousins. Uncle Marshall's the oldest left of the family.
Right.
Well, I don't know. I know. Seems like I got it. But you got his birth certificate, right? Then I see you pull that out.
Well, when we get off the phone, I guess call that GPS guy. Get on him so that he go ahead and come today.
Okay.
And go ahead and get it on. And you know.
This call was terminated because.
Detective Pulley, the voice appears to be a male that said she is going to delay it as much as possible. Do you recognize that voice?
I do.
Whose voice is that?
Devin Pollard.
That's all evidence witness, Your Honor.
Your Honor, I would again renew my objection and state that I can make no comment about confidential attorney-client communication.
Objection is noted and overruled. And you have any questions, I understand the position you're in, but if you have any questions?
Your Honor, it's my understanding from the TBR that I am not allowed to make any comment at all, and to get even close to that might jeopardize my license.
understand that. I'm not saying you made that comment. I'm just simply saying, do you have any questions for this witness?
I don't believe that I
All
can.
right, thank you, Detective. You may step down.
Thank you, Judge.
Mr. Brooks, anything further?
It's important to note in regards to the witness, there are a lot of these cases where that type of expert testimony would most definitely assist the trier of fact to understand the evidence. What is the evidence that that expert can testify to, given the CV that the defense has provided, and even in her motion claims that it's to challenge the veracity of the allegations. And that is only for the veracity, truthfulness is only for the trier of fact to determine. It's important to note that no motion has been filed by the state to introduce the forensic interviews. If that was a piece of evidence I planned to introduce, then I would concede that such an expert would be very beneficial to assist the trier of fact. But how, as far as what the defense can do with that forensic interview, they could use the contents of it to impeach the victim stories. The victims will take the stand and tell their story, and it'll be up to the jury to decide the veracity. So I would argue that this expert witness would, one, not assist the trier of fact in understanding any evidence that the state plans to put on, and two, it is very plain that before the defendant made bond, his intent, now that he was about to get out, was to delay this case as long as possible. So regardless of what Ms. Smith told him in their conversations, his intent for June, as he states on the jail call, was that he is just going to make an appearance. There's not going to be a trial in June. We're going to delay this as much as possible. So regardless of conversations he's had, that's his state of mind before he gets released. So the state would ask the court to respectfully deny this motion for expert testimony, because it will only prejudice the victims in this case, who are both now of age. One is about to go to college. The other one is starting her family, has got a close to a 1-year-old baby, and they want completion in this case, Your Honor. And I would ask the court to respectfully deny it.
The issue of what evidence is to be allowed at trial in this court is within this court's discretion in interpreting the rules of evidence and so forth. As I stated earlier, the typical scenario is you have a very young child, and it's very difficult to tell whether or not a child is being truthful or not in an interview. And for that reason, these forensic interviews are introduced under that statute that allow a child to testify and make statements. And those statements are what usually an expert witness might be called in to testify about the manner of questioning, whether the leading questions are asked or not. That does not apply to a case where there are teenage victims, as was in this case. In addition to that, Mr. Brooks has now stated on the record that they are not planning to introduce the forensic interview. So the question of whether or not the testimony that the jurors are going to hear is credible or not credible is a matter that will be tested in the courtroom. It will be tested by cross-examination and by the rules that I give the jury for interpreting all of this information that comes before them. And we give them, as in the initial charge, a whole set of instructions on how to determine whether a person is credible or not credible in their testimony. So because of the fact that there's no forensic interview that is going to be used, in other words, this expert witness would be asked to interview, to evaluate interviews by the alleged victims that are not going to be used as evidence in this case. And therefore, the testimony of the witnesses in this case is the real issue as to whether or not they are being truthful or not. And that's the same as it would be in any other case. So for those reasons, the court is of the opinion that the motion should be denied based upon the fact that there is no evidence that indicates, nothing that indicates to this court that the efforts of this particular expert witness would be assist the jury in determining the truth of the matter and determining whether or not the witnesses are being truthful, because their truthfulness is going to be tested from the witness stand rather than from a forensic interview. And so the distinction I draw is where minor children, very, very young minor children, are being used as witnesses through the forensic interview with the Child Advocacy Center and so forth, that would be applicable for, or would be appropriate for this witness to be brought in and to testify about the manner of questioning and so forth. And we've had those instances. But in this particular case, with that minor children that are now adults that are going to be testifying, the court is of the opinion that this expert witness's evaluation of those forensic interviews would not be a matter that would assist the trier of fact in determining whether or not the testimony offered at trial was or was not truthful. So your motion is respectfully denied. Now, Ms. Smith, you have also raised another issue. The motion to continue based upon that factor would be denied. What is the issue regarding these phone records? I'm not sure what those records would reflect. And I know you have a motion to continue down on that basis.
Interesting point last time we were in court, which was that none of the records he had provided to me were certified. So I've asked that they be subpoenaed for the purposes of them being properly certified, as well as I stated earlier, Your Honor, one of the alleged victims, AW, we received no phone records at all from the state. And so we are requesting those so that we can get a first look at her phone records, because the other phone records were in fact a treasure trove of information and detail.
So the records that you have subpoenaed are what records?
We've subpoenaed all of the phone records. The phone records for AW's phone. Well, and Judge, these subpoenas are not just for phone records, because you're also asking very specific questions, because they won't send you pictures or texts or Snapchats or anything like that unless you ask for all of that. So we've asked for all digital information for AW's phone.
And you subpoenaed the phone provider?
Yes, sir. And also a phone that she made a comment that she had been using, which I believe at that point was her mother's phone. And then since we were doing that, we went ahead and subpoenaed the other records for CF, one of their friends, and I think that's one of the victims and one of the alleged victims and one of the alleged victims' friends who was involved not only in the initial investigation, but also was involved with initially communicating these issues to law enforcement. So we've got some subpoenas coming so that we can have certified phone records, which we do not have right now, and we have some records coming because we have never seen them before. The companies, Your Honor, have all said that they prefer to do everything digitally. We've issued the subpoenas through the Secretary of State. We have also provided them with those subpoenas digitally. We have made clear to them that although that they can respond to them with the information in whatever manner necessary, that we will have to have that affidavit, which they have been provided.
So you're asking for a continuance based on the fact that you don't think you're going to have those records by the trial date? Trial date is in about 3 weeks, right?
Yes, sir, Your Honor. One of the companies, which is a much smaller company, I think they're based in Alaska, is for AW's phone, and they are supposed to have those, they say they will have those to us probably this week, but the other ones we haven't heard about.
Judge, the proof clearly shows us the delay tactic. The council cites my concerns of certification. That was for the limited purposes of that hearing, because counsel typed her own text messages out, typed her own transcript out from what she saw on a phone dump. So I don't think I have to, educate the court on the issues of that, but I allowed for the purposes of getting to that hearing for those typed out, I guess those copy and paste, or however she produced it from her office, for the purposes of getting to that hearing. However, at trial, I wanted to kind of head that off any potential issues that's not the proper way to introduce that evidence. Like, we're not to do our own transcriptions and say, isn't this the text? There are ways for her, there are ample ways, and I don't want to, I don't want to coach the other side, but there are ample ways for her to certify a phone dump that was conducted by our police department or our sheriff's department that does not require certified records from the phone company. So that, they're ample. My contention was it's not proper to make your own copy, type out your own, transcribe your own text and say, hey, aren't these the text? That's not proper. So the subpoena is not necessary, and there are ample resources for the defense to properly certify anything she'd like to put up there from the phones. The phone dumps were complete in regards to what was contained in the phone at the time. It has been several years since this case's inception. Most phone companies have timelines of information they keep, and we are just now issuing these subpoenas to get these records, Your Honor. This case was, from what I understand, ready for trial the last time, but the only reason why it got continued the last time was because some extra information was provided from our kids, and that was in regards to some STD testing, which has no relevance to a phone dump. I can't conceivably see how those STD tests would prompt an attorney or a defendant to go, we got some STD testing back. Let's subpoena the phone records now, 3 years after this case's inception. I think from the proof that I have previously submitted, this is nothing more than a delay tactic, Your Honor. I would ask the court to consider the victims. Every time this case is continued, they have to take another hit. We also have another defendant charged in these crimes who's in jail, who's charged under a different indictment, whose testimony will be required at trial, and she continues to be in custody while this case is pending. And she is set in July on Judge Suzanne Locker-Mash's term. I would ask the court to respectfully deny this motion.
Well, this case has been pending since 2011. It's been set for trial numerous times and has been continued numerous times. And when we set it for the June 25th date, it was a date certain that we were going to set, and that was part of the reason that I granted the defendant a reduced bond and allowed him to make a bond that he could reasonably make because of the fact that he had remained in jail, and Ms. Smith had argued very passionately that his rights were being infringed because the state's continuances in the past and then providing information that required her to ask for a continuance at the last minute. Both sides have the right to put on their case. The defendant has a right to present whatever proof they wish to, but in a case where it's been pending for this length of time, this information should have been and could have been, in my opinion, brought to the fore and obtained in some other method by what the court finds to be appropriate. So I'm of the opinion that there's not a basis for a continuance of this case at this moment. And for that reason, the motion to continue for these phone records is denied. any other reason that needs to be raised, and I understand that there may be one, but it is important to try this case, and I think that under the circumstances, we set it for that June date with the anticipation that it would not be continued again, and set aside the entire week for that trial to take place. So, Ms. Smith, I know you have some other issue. You're going to need to file your motion for that purpose and set it for hearing, and we will deal with that at that point. If you, I can do it tomorrow morning if necessary. You can get the motion filed. So I know you don't have an assistant to file it for you or to draft it for you, but I think the point is that Mr. Brooks is entitled to some sort of notice about your motion to continue on this other basis. And I think that if we don't do it then, we would have to do it in Houston County on the 17th, well, 24th, which is the day before trial, and that's not going to work. You want to just allow it to be made let's make you're making an oral motion to withdraw, is that correct? All right, then we'll set it for tomorrow morning at 9 o'clock and, okay. 1:30 tomorrow afternoon. I already have a matter set, so we'll just have it tomorrow afternoon, 1:30. I have a motion to suppress it to Jesse Kinder. Anybody have that case? We'll do your motion to withdraw tomorrow at 1:30. All right, thank you. We will, I guess that means we are adjourned for today then. General Wojnarowski, do you have anything that I need to deal with? You're here for moral support. So, all right. All right. Stand adjourned.
Peter went dead, so I want